if the corporation has no assets. But the fact alone that the corporation had no assets does not entitle somebody to go after somebody individually.
Okay.
Last entity, we got to move. LLC. LLCs are the new darlings. Everybody likes them, but people just aren't used to them yet, and they're a little uncomfortable with them, and they're not quite sure, as investors, what type of ownership interest they're getting, and it makes them nervous because they haven't done it before. If you invest in an LLC, you become a member. And that's kind of a strange thing. People say, I'm going to give you 100 grand, but I'm going to be a member. Hell, that's like my country club. You know, I want something. I want a stock certificate. I want to know that I'm a partner. I want something here. So if you invest in an LLC, you're a member. And there is one member who is deemed to be the managing member. And the managing member, even the managing member, does not assume personal liability. It just manages the LLC and signs stuff for them. Theoretically, like in a corporation, nobody's liable for anything. The managing member is not liable. The members are not liable for debt or for personal injury. The LLC is a darling again because it's taxed only once like a limited partnership. The one thing that makes them really attractive in an LLC is if you have what we call a single member LLC, and that's what we talked about before, where there's really only one person here anyway. What that means is for a single member LLC, the LLC doesn't even have to file a tax return. In all these other cases, the entity, the business organization, had to file a tax return. The questions were whether it did or didn't pay any taxes. C Corp, S Corp, both file tax returns. Limited partnership files a tax return. LLC files a tax return unless it only has one member. And if it only has one member, it doesn't even have to do that. That means you don't have to pay an accountant to do a tax return every year for the entity.
You still have personal taxes, though.
It's taxes on the profits in terms of the member. The members still pay the taxes on the profit, just like the limited partners did, just like the shareholders did in an S Corp. There's still tax, but there's not a separate tax return, which is a pain. Now, if there's two members, yeah, you got to file a tax return. It still sends all the income off onto the individual's returns. It still doesn't pay tax, but you have the paperwork of having to file a return, which is kind of a pain. Now, LLCs, they will, I predict, soon be accepted and will be what everybody wants to use. And one of the biggest reasons is because of that single member LLC, it skips a tax return. Every other entity has a tax return. Meaning, every year you pay your accountant to do a tax return for the entity, and then for yourself individually too, as you're used to that. But every time you form one of these entities, you're getting your accountant to file another tax return for that entity every year, and you're paying him for it. Or you're doing it yourself. Either way, the pain is there. With a single member LLC, you don't have to. Unlimited members, you could have 1,000 members in an LLC. They're all members. It's just that people aren't used to them yet, and when they take them to their lawyers to look at them, they're not so sure of what the law is and what your rights are going to be and how much control you're going to have or not have, how much liability you're going to have or not have. They're just not used to them yet. Banks aren't used to them yet either. Banks aren't sure how they know who they're dealing with and how they know that that guy really is the managing member. And so it's coming, but as yet it's not as acceptable. But it's got a lot of benefits.
Does the amount of money that runs through a single member LLC matter?
No limit. No limits on any of these things on how big you can be dollar-wise.
Okay.
S Corp.
No, I mean as far as whether or not you have to file a tax return.
No.
Okay.
No. The tax return is determined by how many members you have, but not how many dollars.
Can you change if you're an S Corp to an LLC?
I'm sorry?
Can you change fairly easily if you're an S Corp to an LLC? Or do you have to start a new company?
Yeah. There are ways to do it under Florida law that are just so painful. You've got to form the second entity, and then you merge them. And then you have one of them be the survivor. You can't just come in and say, I'm an S Corp, I'd like to change myself into an LLC. You would have to form an LLC and then merge the two entities, and then you have a merger agreement that says all the shareholders became members, and it's real painful. Yes, sir?
And for REE, what could you be any one of these if you start a REE?
A REIT?
Yeah.
REIT? No, an REIT is a trust.
So
And
that's-
it's none of these.
It's
It
none
is
of
none
these.
of the above. We're going to talk about trusts in just a minute.
Okay.
Not really even REITs we're not going to talk about. REITs were in such favor in the 70s and 80s. I don't hear about them much anymore. I think the text mentioned them for a minute, but it's not it's not the type thing we're talking here about where a couple people get together to buy a piece of real estate.
Okay.
Now, I'm going to tell you real quickly how you form these things, but you're not responsible for this, but I just want you to have a flavor of the documents you file on the record and off the record to understand most importantly, that with one very limited exception, stuff that you put in the public records does not tell the public who the real owner is. Who the real money guy down here at the bottom of the pyramid here that really owns this thing and has put up all the money is not disclosed in the public records unless you do a general partnership. And that's another one of 25 reasons why you don't want to do a general partnership. If you form a corporation, whether it's an S Corp or a C Corp, you file with the Secretary of State, we're going to talk about Florida, of course, you file articles of incorporation. Short, simple form. You say, here's the name of the corporation, here's where its office is. You say whether or not it's going to have a board of directors. You got to mention at least one officer, but that person's only an officer. That doesn't say he's the owner. And that's it, and that's all you tell Tallahassee. And every year you file a little report that says the same little thing. Yeah, we're still at that address. Yeah, this is still the president, and this is still the treasurer, and that's it. And that's all you're telling them. You're not telling them who the stockholders are. Off the record, you issue stock certificates to the stockholders. You might have a shareholders agreement among all the stockholders. You have bylaws that determine how we're going to have meetings and that's crud. Who's going to vote and notice and all that kind of stuff. But that's all off the record. And none of that discloses to the public who the real owner is, who the stockholders are. You don't know who the General Motors stockholders are. I don't either. And there's no place you're going to be able to go and find out. And they ain't going to give you a list. General Motors is not. But the Secretary of State of Delaware doesn't know either. Stockholders are not disclosed, and those are the real owners. S Corp or C Corp. Now, with a limited exception, in the S Corp, IRS is probably going to know who the shareholders are in an S Corp. And the reason is because in an S Corp, everything we said a minute ago applies to an S Corp. Articles of incorporation, all this stuff is the same. Nobody knows who the shareholders are if you go check with Tallahassee.
In the LLC as well.
I'm sorry?
In the LLC as well. In the LLC.
No, I haven't got there yet. In the S Corp though, in the S Corp, you're not disclosing who the shareholders are either to the Secretary of State or to the public records. You are disclosing them to IRS because one of the tax forms that the corporation files says we gave all of our income to these stockholders. So IRS knows. But that's not a matter of public record. Now, and that's why in a general partnership, if you filed with the Secretary of State, which you don't have to do, you'd be filing your partnership agreement, and that tells them who the partners are. So that's another reason people don't use it. There's no confidentiality there whatsoever. In an LLC, the limited partners are not disclosed to the Secretary of State.
LLC?
I'm sorry, I apologize. Limited partnership. I misspoke. In a limited partnership, The limited partners are not disclosed in the public records anywhere. You file with the Secretary of State what's called a short form certificate of limited partnership, and all that says is, here's our name, here's our address, and here's who our general partner is. Here's our sacrificial lamb, the one thing that's liable. Could be one person, but it's not. It's the corporation. But the limited partners are only signing a separate document, which is called the long form partnership agreement. There's a long partnership agreement then among all the limited partners and the general partner saying, here's what we're going to do, here's what we're going to do if we need more money, here's the tax returns we're going to file, here's the reports, here's what the accountant's going to do. All the agreement that affect how that thing's going to operate. But that's all off the record. Nobody can find it. LLC, very similar, same thing. On the record, you file a short little form called the Articles of Organization that says this is going to be the name of the LLC. And this is who's going to be the manager or the managing member. Forgive me, I didn't make that distinction before. And LLC has to have a manager or a managing member. If a person is a managing member, well, he pretty well have disclosed he's a member. But it doesn't have to be a managing member. You got to have a manager or a managing member. And that's all you tell the Secretary of State. And all the other members in the off-the-record management agreement is what you call it. Instead of a partnership agreement, you call it a management agreement, and it's all about how this LLC is going to be managed. And how you know initially that you're dealing with one of these things is you look at the name. We talked about in a corporation, you got to be an Inc. or a Co. or a Corp. In a limited partnership, the name has to either contain the words limited partnership or it has to say LTD, period. And you know you're dealing with a limited partnership. You know then that you better be getting the signature of the general partner. If you're signing a contract with them, make sure you're getting the signature of the general partner. If you don't know who it is, go online with the Secretary of State and see who the general partner is. And if you see it's a corporation, then go online further to the corporation and see who the officers are. Make sure you're getting the right person. Because the point is we're talking about who these people are that manage them. And that's important to you because if you're signing up some sort of an agreement with one of these entities, if you don't get the right person signing it, your contract is worthless. With an LLC, you got to have the signature of the manager or the managing member. Go check with the Secretary of State, see who that is. When you sign a contract with them, make sure you got that entity. You got that party, the manager or the managing member, signing on behalf of the LLC. That's kind of it. That's all I have to say about these entities. I got a couple more quickies I want to talk to you about that are not in the chart, but were in the text.
What type of costs are associated with starting these?
It varies in each case. The filing fee with the Secretary of State, in no case do I think is more than $1,000 to file the first year. And every year you file an annual report that's usually, I think, $150.
Yeah.
But those vary too. I think limited partnership annual reports, I think, are $500, I think. In a limited partnership, you declare how much stated capital you're going to have. And if you declare over a certain amount of stated capital, your filing fee goes up. The fees are all published by the Secretary of State. They're no secret. A lawyer or whoever forms the entity for you, he's going to charge you a separate fee for his job of putting these documents together. Mm-hmm. And then there's a filing fee when you file it with the Secretary of State to actually create it and set it up. Okay. And then there's an annual filing fee every year where you keep it alive, where you keep it active. And that's really just a report to say, yeah, we're still here, we're still alive, this is still our office, this is still the guy that if you want to sue us that you serve process on, and he'll have an office somewhere within the state of Florida. Mm-hmm. And here's who either who our officers are, or here's who our general partner is, or here's who our manager is, so that you know who it is that you're supposed to be dealing with.
Okay.
Any other questions on these? We got a couple more entities I want to talk about for a second. The materials mention a joint venture. The joint venture is used very rarely in Florida. And what a joint venture is nothing but a partnership. A general partnership. So it's got all of the negatives we talked about a general partnership: unlimited liability, full disclosure if you file of who your partners are. All a joint venture is a partnership for one deal only. If you and I decide to get together to develop one parcel of land and we agree that's all we're ever going to do, and this joint venture will never have another project, then we can have really a partnership, but we can call it a joint venture, and that's because it's limited to a single part. A general partnership can go out and do anything it wants to, buy dozens of pieces of property if it wants to, but a joint venture would only be one. Pretty rare, it's not used. The last thing I want to talk to you about is a trust. Now, this is not a real estate investment trust, which is a syndicated investment gadget, which is regulated heavily by the securities laws. That's not what we're talking about. We're talking about a land trust. A trust for the purpose of holding title to land. These are a great way to go in Florida, depending upon who's going to be your trustee. Now, like any trust, you have what we call the grantor, the person that sets it up, the person that funds it, but he appoints a trustee. And the trustee manages the assets of the trust, has fiduciary responsibility to beneficiaries, the person he's holding title for. And what that means in Florida is, or anywhere, is it is the trustee that holds title of the land. Title is taken in a land trust in Florida by saying, Joe Blow as trustee of the XYZ trust. You name the name of the trust, but you do not put title in the XYZ trust. You put title in the trustee. In all these other cases we talked about, you put title in the corporation, you put title in the partnership, put title in the LLC. You don't put title in the trust here. You put title in the trustee. These were started in Illinois, and they're still called Illinois Land Trusts. We have a great statute in Florida. We have a great land trust statute in Florida that totally outlines the rules, the laws, the responsibilities of a land trust and the land trustees and the land trustees' authority. In the 70s and into the 80s, these were used very heavily in Florida to take title of real estate. And people used banks as trustees. And Bank of America, as trustee of the XYZ trust, would take title to a piece of property. And there would be a separate trust agreement off the record where Bank of America would say, I'll be your trustee, and all you people are the beneficiaries. I'm answerable to all you, and all the money goes to you, and you own this thing, not me, the trustee. But the beauty was, it was absolute secrecy. The banks, just like the Swiss banks today that we hear about with all their secrecy, the banks would never, even under penalty of court order, disclose who were the beneficiaries of the trust. They would stonewall it, and they would never disclose. And all anybody could ever see of record is title is held by Bank of America as trustee of the XYZ trust. And of course, if XYZ isn't the word Disney or something, then you don't know it's Disney. This is how Disney acquired all the property for Disneyland. Sorry, Disney World, excuse me, all over Florida. They sent different trustees around as trustees of the A trust, the B trust, the C trust, and acquired all this land so everybody didn't find out they were dealing with Disney. Because as soon as the word would have hit that Disney's buying up all this property, prices would have doubled, tripled, quadrupled. They were a great vehicle for secrecy. They were also the favored vehicle for offshore investors. They provided absolute secrecy to all of the investors from the European countries and the South American countries that had currency control, where these people weren't allowed to take currency out of the country. So they bring money up here, set up a trust, have a bank as trustee, and all anybody knew and all their foreign government back home knew was that Bank of America owned this piece of property. They don't know nothing. That all worked great for a long time. Federal government passed all these environmental liability laws that said the title holder of a piece of property is liable. And quickly the banks started going, huh? I don't want to be liable for that. I don't want to be liable for holding title to Joe's pool service property over here, and he spills all this chlorine all over it, and it gets into the underground water supply, and it's got to be cleaned up. Hell, we don't want to do that. So almost overnight, all the banks said, we're not being land trustees anymore. Go find yourself another land trustee. There is now only one bank in Florida that does it, and it does it by getting insurance in each case. No, if you would, under the trust agreement, the beneficiaries always said to the trustee, oh, don't worry, we'll take care of you, we'll protect you. You know, oh, sure, trustee, if you have a problem, we'll pay you back, don't sweat it. Well, these were liabilities, these environmental liabilities we're talking about, were hundreds of millions of dollars. And the beneficiaries weren't necessarily good for it, but Bank of America was. So they didn't want the liability, that's why they got out. It's still an excellent vehicle today if you use an individual as a trustee. Let your lawyer be your trustee. Let your accountant be your trustee. Let your kid be your trustee. Whoever it is may have some limited liability in the event of environmental issues, and may have liability for the personal injury that we talked about. But you can buy insurance for that. But the beauty of it is it keeps it totally secret who the owners are. It's a great way of doing it, and it's still very viable in Florida, and it's done. The trustee is not liable for debts because when the trustee signs a note or mortgage, it always says, not individually, only as trustee of the trust. And it's good, yes?
Is it easier to change ownership through the trust?
Is it easier to do what, sir?
To change ownership, like if you want to...
I'm just not following the questions. It's easier to do what?
To change ownership, to sell it?
You mean to sell as a trust? Oh, the trustee signs a contract to sell, just like anything else. It's no easier or harder to sell. If I'm looking at a piece of property to buy and it happens to be owned by a land trustee, that doesn't scare me off. I mean, it doesn't mean there's anything sinister going on here or a problem. It just means that that land trustee is who's got to sign my sales contract. That's who's got to sign the deed. That's who's going to get the money at the closing. But it doesn't hurt a deal. It doesn't help a deal either one. But what it tells you though is that you're not dealing with the real owner.
Yeah, for the real owners inside the trust. If I want to give it to my sister, then
Okay, we're talking about two very different things. You're talking about a trust that's used for estate planning purposes or for a testamentary trust or a revocable trust or an irrevocable trust or a testamentary trust. All these things are estate planning that you're talking about what you want to happen, like if you become incapacitated or if you die. That's not what we're talking about here. We're talking about a vehicle to own title to commercial property that has benefits as a way of owning the property and as a way of operating the business of the ownership, the income, the expenses, etc. but we're not talking about estate planning. Totally different issue. As I mentioned, there's still one bank that'll do it. It's City National Bank of Florida. The fees are hefty. They require that you have insurance to cover them against everything in the world. But they're still willing to do it. And a lot of South American investors love it and are still using them. But this is called the Florida Land Trust. It used to be called the Illinois Land Trust, and this is a vehicle for owning commercial property. This is no way you'd want to own title to your house. Even in the situation we talked about should you put your house in your revocable trust, that's not what this is. It happens to be the same word trust, but it's a totally different animal. Okay? All right.
Can you refinance if the property is in a trust?
Sure. The lender's going to require the beneficiaries to guarantee the loan,
Okay.
for sure. And under federal rules, under some types of FHA and VA housing, they don't want you to have a trustee. There's certain limitations under borrowing programs that don't favor having a trustee. But the trustee, whoever it is always going to say, I'm not liable for the debt. And when he signs, is going to require that there be in the loan what we call an exculpatory paragraph, where the trustee says, the trustee is signing solely as trustee and not in his individual capacity, and none of his individual assets are liable for this debt. The holder of this debt agrees solely to look towards the assets of the trust and not the assets of the trustee. And then when he signs it, he's going to say as trustee and not individually. The trustee is going to be trying real hard to make sure that he's not liable for the debt. And for that reason, the lender's going to say, bring the beneficiaries in here to sign a guarantee.
Right.
Because they're the ones who are getting the benefit of this anyway. You know, that's whose property it really is. It's the property of the beneficiaries under the trust. It's just that a trustee is holding title for them. That's all it is. A trustee, we call, holds naked title for the benefit of the beneficiaries. He's not the real owner, but he's the record owner. And he's the title owner. Just like, theoretically, General Motors. The real owner is the shareholders of the corporation. You know, at the bottom end of all of this, when you get all the way down there, but and something other than the real owner is holding title. And even when we said when there's only one guy, and he forms one of these entities, still not that one guy holding title. It's the entity holding title. And the reason they're using the entity is for the liability protection.
If you had several beneficiaries, they would have each one of them sign on that note?
Is there any benefit to whom?
If there was several beneficiaries.
Yes.
They would, and you're doing a refinance while a property is in a trust. They would have each one sign on it?
Maybe, maybe not. The bank is going to look at the financial statements, each of the beneficiaries, and they'll make an underwriting decision of which ones are worth having and which aren't.
Okay.
It may be that 2 or 3 of the beneficiaries have no assets. What's the point of putting them on here?
Right.
You know, if they submit a financial that says, I own nothing other than my interest in this trust. If the bank forecloses, they're going to get the property anyway. So there would be really no benefit to having those guys. The heavies are the ones who sign the personal guarantees. Okay. That's it for chapter 5. Yes, sir. Chapter 5, we'll move on to 6, hopefully. Yes.
I had it's kind of not pertaining to this, but the intangible tax in Florida,
Uh-huh.
how does that work? Like if you take a charter boat into international waters and you sign a contract on a property that you don't have to pay intangible tax?
I didn't hear the question.
All right. That's a question of documentary stamp tax and intangible tax if you have a mortgage. Basically what we're talking about is recording fees. They are taxes that are imposed at the time you record a document. And there is some law that if you enter into a contract outside the state of Florida, you are exempt from some of those taxes when you record those documents. It can be done. It's a way to get out of paying taxes. I'm not going to begin to outline a procedure for you such that you'd be able to rely on me telling you that, because that's something a tax lawyer would tell you. But certain types of obligations that are taxable if they're entered into in Florida are not taxable if they're entered into outside the state of Florida. And that's the doctrine you're traveling under.
'Cause I
That's
got
kind
a-
of the same as
I got a banker
Amazon.
friend that goes on a charter fishing boat
I'm sorry?
monthly.
Doesn't have,
For that.
okay, I mean, some people some people have a boat, and they don't have to charter a boat to do it, you know. But I mean, the question is not about charter fishing boats, the question is about entering into a transaction outside the state of Florida. And if you're in South Florida, it's easier to get outside the state of Florida in a fishing boat than it is to cross the border into Georgia.
Right.
If you're in Jacksonville, you just go over the border. The point is entering into a transaction outside the state of Florida is what it's all about. It ain't about fishing boats are exempt.
No,
It's
I
about
know
entering
that.
into a
So, yeah,
transaction.
go
Yeah, it's
50
about entering
miles
into
an
a
hour,
transaction
international
outside
waters.
the jurisdiction of the state
Yeah.
of Florida. But those are really recording taxes. One-time only recording taxes that are imposed when you record a document. Yes, ma'am.
I haven't buy real estate using a trust in Florida or the US, but outside. If you buy property here and with 5, 6, or 7 different investors, tag along applies when each individual investor wants to sell their interest into the trust? Or it's just a matter of an operating agreement between the trust and the investor?
Well, in all of these cases, individual investors, whether it's a member, whether it's a limited partner, whether it's a beneficiary in a trust, or whether it's a shareholder, in all of these cases, they can all sell their interest to somebody else, to another partner that's already a partner, or already a shareholder, or already a member, or to somebody new. And that applies also in a trust, that the beneficiary, the beneficial interest in the land trust, being the right to be a beneficiary, that's also saleable. You can sell it. And in none of these cases, if you do that, does that require a deed changing the ownership of the property. The entity in all these cases still holds title. The corporation, the partnership, the LLC, the trustee still holds title to the property. But off the record here, the investors are selling their investment or trading with each other or saying, I want to get out, will you buy me out? All those things are possible, all off the record.
It's a matter of an operating agreement, how they design it.
Exactly, it's exactly a matter of what does the partnership agreement say?
Okay,
What does the management agreement say? What does the trust agreement say?
okay.
And in almost all of those cases, it requires the approval of the other investors. If 3 of us have gotten in a deal together because we're buddies, we're gonna have an agreement that says, before you can get out, you gotta either offer it to me, or I gotta approve who you're gonna sell it to, because I don't want you making me partners with a new partners, and I'm using the term loosely, with a new person without me having some say-so about it. So in entities where the size is manageable, you'll have an agreement like that. In General Motors, you won't have an agreement that you can't sell your stock unless we approve who it is, because that's all on the open market, on the stock market. But as the entities get smaller and smaller, the individual investors want more and more control of who are my partners going to be, who are my co-investors going to be. And when it gets down to within families, of course, you very clearly have those restrictions, where you have a family limited partnership saying, you know, I don't want you selling to somebody outside the family. So yes, there are different type of restrictions imposed in the off-the-record document we talked about, whatever type that off-the-record document that may be, whether it's a shareholders agreement, a partnership agreement, a management agreement, a trust agreement, any of those cases, if the entity is small enough and it's not like a public corporation, there are going to be restrictions in there on saleability and transferability. Okay. Chapter 6. Chapter 6, the text is very well written. I know I've been critical of a lot of things that the text has done. I'm thrilled that with this very complicated concept of what does condominium ownership really mean and what is cooperative. Sure, absolutely. what does cooperative ownership really mean? The definitions in the text are great. And I'm going to refer you back to them in a couple of cases. Condominium. The definition in the text is great. I'm going to read it. I commend it to you. It's fee simple ownership of one unit in a multiple unit structure, combined with ownership of an undivided interest in the land, all of the land, that's important, and all other parts of the structure, that means outside the unit. And that undivided interest is held as tenants in common with the owners of all of the other units. Now that's a mouthful, but it's a great three-line definition of what a condominium is all about. Let me draw a little something, just to make sure that that all makes sense. We have a piece of land. We have a building on it. We have individual condominium units in the building. Okay. This whole thing is called a condominium. Single story here. Now let's make this a two-story. This is a two-story building, and that's what the units look like on both floors. That means we got 12 unit owners. We've got 12 unit owners, each of whom owns a fee simple title to his unit. In addition, since there are 12 of us owners of the condominium as a whole, each unit owner owns 8.5% interest as an undivided interest as a tenant in common of all of the common areas. We're going to talk about those in a minute, common elements, the common areas. Now those common areas, remember what they are. They are all of the land, okay? Every single bit of the land. It's easy to get the misconception that the guys on the ground floor own the land underneath their unit. This guy has no greater interest in the land under his unit than any of the guys who live upstairs from him, or from any of the other 11 owners. All together here, all 12 of us unit owners each own 8.5% interest in every bit of the land. That means the entire parcel, including what's under the building. That of course means that,
There it goes.
that we all own 8.5% interest in the swimming pool. We all own 8.5% interest in all these parking spaces that are out here. We all own 8.5% interest in the hallway, in the staircase. We all own 8.5% interest in the outside walls of the building. We simply have fee simple title to basically the interior walls of our unit, and we own in common as tenants in common with the other 11 unit owners. We each own everything else together, the common areas, which means everything except the unit. That's a condominium. Concepts get a little more complicated than that, we'll talk about them. But That's the basic structure. They can be on one floor. They can be on 20 floors. It clearly requires a multiple unit structure. You couldn't have one unit. It's been done, but it makes no sense to have a single unit condominium. Now, there's a good paragraph at the bottom of page 110, and it continues on the top of page 111. And I'm going to paraphrase what it says, but I commend the reading of it to you, because it really explains how do we get here. A developer either buys that whole vacant piece of land and he builds this thing, builds his building, or in something called a conversion that we're going to talk about, he buys an apartment building that's already there. But he either buys the land and builds the building, or buys the land with a building already on it, and in either case decides he's going to create a condominium. After he's done that, and we'll talk about how you do that, he's then going to deed to each unit owner fee simple title and a deed to their unit. But in addition, that deed is going to carry with it the ownership of an undivided interest in all of the common areas. So that way the developer has gotten rid of all the interests. He's gotten rid of the unit, and he's gotten rid of the undivided interest in all of the common areas. Now, the developer goes on to talk about financing a little bit. The developer may have gotten a construction mortgage, he may not. That's not really relevant. What is important, though, is that each unit owner can get a mortgage on his own unit. And that's a biggie that we're going to talk about in condominium. Yes, sir?
Can the developer retain the rights for like the pool and the parking lot, but not the responsibilities, and lease it back to the condominium?
Yes. That can be done. That's a leasehold condominium or a condominium with a rec lease. Both are hugely disfavored today, not only by the legislature, but also by the division, but most importantly by purchasers. Purchasers that come in and take a look at this thing, they want to know, is there a rec lease or a land lease? I'm not buying it.
But is that the banks that look at that? Because most purchasers wouldn't.
There's no what, I'm sorry?
Is that the banks that are looking at that? Because most purchasers aren't gonna read through the condo docs to see that.
If they've got a good realtor telling them that this condo has a rec lease or doesn't have a rec lease, they're gonna find that out. Secondly, in every form contract that I've seen for condominiums, there are sections where you check off, is there a rec lease? Is there a land lease? Are there any other social agreements that I'm required to become a member to, that I have to pay dues, I have to pay amounts on? You might fog it by one or two purchasers, but in a large sense today, I don't think you're going to be able to market a condominium like that. There are still some around that are like that.
My grandfather did it a bunch of times over in Venice.
Yeah, how recently has he done one?
No, I mean, that was, 30 years ago.
No question about it.
But he's
When
got
condominiums first came out, that was the rage everywhere. That's what they all did. Developer thought, this is really cool. I can build a building, and I can lease them the land under the building. And for 99 years, they'll have to pay me rent.
Yeah.
And the rent will go up on the CPI. And in addition, I'll own the rec building too, and I'll make them all be members and pay me dues to come down here and play ping pong and to use my swimming pool. And they're gonna pay me dues for that, and that's gonna go up for 99 years.
Yeah.
The legislature written all kinds of rules to restrict that kind of stuff, and in virtually every one of those properties, the association has levied an assessment to each of the members, and they've gone and bought the guy out.
Yeah.
So that it's become real common elements again. But what I'm getting at is, I assure you, if you build a building right here with a rec lease, with a 99-year rec lease, with an escalator in it, and you try to market that thing to the public today, the realtors, now, theoretically, the units would cost less, but I don't think buyers are going to be interested. That's my personal opinion. I think buyers have become more sophisticated and they know to ask those questions. But they didn't in the old days. Hey, this is cool. And units in those buildings, of course, cost less because the developer didn't have to factor into his sales price of each unit 8.5% of the value of the land. Hell, he was keeping the land. So he could sell a cheaper unit. Look great. You know, I can buy this unit for 20 grand and the unit just like that in the other building costs 30 grand. I wonder why. Well, because the 20 grand one had a rec lease that I was paying on for 99 years. The one that cost the 30 grand unit, I was an undivided interest owner in the lease. I'm going to stay away from that kind of stuff because they're, no, I say in the sense of, yeah, that's one of the exotic permutations that you can do, but it's not your average condominium today. And most condominiums where that even was done, it's been undone by, now, and what, of course, what the legislature did, the legislature by statute said that those escalator clauses in those leases are void. We don't care what your contract says. They are void as against public policy, and that rent may not go up. All of a sudden, it ain't so attractive to the guy anymore anyway, if he's going to have to get the same rent figure for 99 years. But, you know, they were going up on the CPI index and doubling and tripling, and back when we had inflation, and that cost of living increase was 15% a year, and the rents were going up like that. I mean, they were wonderful for the investor, and that's, of course, why the people who were paying them raised hell with their legislators and got them to pass a law to say, period, we declare them as void as against public policy. Okay, that's basically how a condo is set up. Now we're going to talk about the little mechanics of how you get there. And the first thing is, to create a condominium, you file a document called a declaration of condominium. Most people call it the declaration, some people call it the deck, people that are really in the business. I got a copy of one here with me. If anybody cares to look at it after hours, I would have sent you one to read. They're maybe 100 pages long, they're complicated, we don't have the time to go through it, but if anybody wants to look at one, I'd be glad to walk you through it. Declaration is a good word for it, because on the first page of every one is the word declare. I, the developer, declare that I own this piece of land, and here's the legal description of this piece of land, and I declare that henceforth this piece of land is going to be a condominium. And you record it in the public records, and it has all kinds of drawings and surveys attached to it, and from that point forward, that land, rather than being known as Lot 8 of Block 3, will be known as Happy Acres Condominium, period, forever. In the tax rolls, tax assessor's going to start sending tax bills to the unit owners. That land forevermore is a condominium, until, of course, the condominium gets terminated for some reason. Obviously, anything you do could be undone, but that is how you create a condominium. You record a declaration. Now, it's going to contain legal description of the property, as we talked about. It's going to talk about all of the areas that are under common control. It's going to have a description of what the units are like. It's going to have surveys of the units. It's going to show you the square footage of each unit. It's going to show you the unit number and the floor number. And all this stuff, so you specifically, by looking at that declaration, know what Unit 202 looks like. You're going to see a survey that shows Unit 202 is on the second floor, and these are its dimensions. Forevermore, you know what Unit 202 is going to look like. In addition, it's going to set up this fractional interest. It's going to say how many units there are in the condominium and what fractional interest each unit owner is going to own. Now, know, if you would, that they're not necessarily all going to be equal. we might decide that on each floor, we want to have a big unit. And therefore, these percentage interests are going to be different. Normally, they're done based on square footage. They're not required to be. They're required to be set out in the declaration, but normally, for fairness, they're done on square footage. So that the guy with the big unit on the first floor should own twice as much interest in the common elements, and as we'll talk about in a minute, will pay twice the expenses of the guy next door whose unit is half as big. And similarly, the guy on the second floor, if it's built the same way. And know, if you would, that the fact that I showed you this as if it's on the same on the first floor and the second floor, that's not necessarily the case either. Every floor can be different. You can have all big units on the first floor, you can have all little units on the second floor, you can have medium-sized units on the third floor, you can mix and match. That's why they're all drawn and they're set, and they are, you can consult the surveys to see exactly what the dimensions are of each unit forever, as long as that building is there. Yes, sir.
Does that give you a larger say in the association, or more access within the common areas, or is this all by bylaws and stuff?
Means nothing.
No, you just pay.
Doesn't mean you get to use the swimming pool twice as often, it does mean that you're gonna pay twice as big a share of the common expenses.
But it can, if the bylaws allow for it.
And the bylaws are gonna provide that. And the unit owners are gonna insist that it be, because they're gonna say, this guy ought to be paying twice as many of the expenses. He has
I want
twice as
this-
big a unit. Now,
I
he's
want-
gonna argue, well, no, wait a minute. There are two of us living here, we have the same 2 cars you do, we're only using 2 car spaces, just like you guys in little units. There's all kind of arguments, but traditionally, it has come down based on square footage.
Okay.
You can say, in this case, you can say, nope, this is gonna be 10 units, and everybody's gonna have 10%. You can do that if you want to. People may or may not like it. People may or may not buy it.
Yeah.
People may or may not buy a small unit if they think the guy in the bigger unit next door is only gonna pay the same share of the expenses I am. And it may be that the big units will sell out fast and you won't be able to sell the small units. You know, but the point is, it does not have to be done on square footage. Traditionally, it is.
Yeah, like say if there's a penthouse and it has a pool up there,
Absolutely.
is it only to the penthouse owner?
Penthouse, you know, could be a whole, yes, a penthouse unit can sometimes be an entire floor.
Okay.
Often is. Or sometimes there'll be just 2 units on the top floor.
Yeah.
But they are definitely going to have their percentage ownership interests allocated in the declaration.
Okay.
They are not necessarily going to have their assessment percentage that we'll talk about in a minute, that's getting a little ahead of ourselves, set up on the declaration. That's something that the board can decide.
Okay.
Any questions up to this point, as far as we've gone? Because you gotta grasp this concept, or then going forward, none of this stuff's gonna make any sense. But we talked about tenancy in common before. Your tenants in common with all your neighbors. As to all the land underneath you and underneath me and underneath everybody. One thing we talked about with tenants in common, we said no matter what, you absolutely by law as a tenant in common have the right to partition. Think of what a nightmare it would be here if you did. So the condominium law and each declaration say, even though you are tenants in common owning undivided interest in this land, you do not have the right to partition. You may not sue to partition the common areas, because that would destroy the whole building. Would destroy the entire condominium, wouldn't necessarily destroy the building, would destroy the entire condominium ownership. Yes, sir?
That's just stated on the declaration?
I'm sorry?
That's just stated on the declaration that
The
you-
declaration traditionally says it, that you may not have the right of partition. The condominium statute definitely says it. There shall be no right of partition among the unit owners as to their common areas. Okay. The declaration's gonna contain all kinds of other stuff too. It's gonna be 40, 50 pages long. It's gonna contain a bunch of restrictive type things. and there's one that I want to talk about in particular. It's going to provide that you can't sell your unit or you can't lease your unit without the approval of the board of directors. That's important. People who buy condo units as speculators have a problem with that. Yes, ma'am.
No, I was just asking you to repeat that. You can't sell or lease your unit without the
Approval of the board of
directors?
Uh-huh. And they all say that. Now, they say it in different forms. Like if I sign a contract to sell my unit, the buyer has to fill an application. You don't have to write this down. This is practically what happens. The buyer has to fill in an application. The application gets presented to the board. The board may want to meet with the member and see what they think of them. And the board decides whether or not to approve that purchaser. Does the board want my buyer to be a unit owner there? They're going to examine his financial wherewithal because I want to be sure he can pay his share of the expenses. They may want to see whether he's a child molester or not because there are kids in the building. They're going to check him out. And they may say no. And under some declarations, no means no, that's it, it's over, you're not selling to that person. Under other declarations, the board has the right to buy the unit. So at least the board, at least the seller gets the benefit of his deal, he gets to sell his unit. The board buys it on the same terms. But then at least the board gets to decide who they sell it to. At least they kept that guy out of there. This is a huge area of litigation. Imagine you're a seller and you've been on the market for 2 years and you finally get your unit sold and the SOB board of directors turns down my buyer and my deal is dead. God, no.
Do they have to give you a rationale for why they've done it?
Well, don't they pass that law this summer that they have to?
Some say that, some declarations say that they have to specify why. There are rules of the division that come into play that I'm not totally up to date on because I don't keep up with them, but they have the right to simply say no. And frankly, the more they say, the more trouble they get into. It is a huge area of litigation. Yes, did you have a question?
Yeah, no, I just want to add something. There's a case in Brickell where there's a big tower. The board heard that the tower next door, which was very small, very outdated, was going to be bought by a developer in his entirety, turned down and built another high-rise. So the board of this building decided to buy individually 3 units on that building. So they were not going to sell it.
Okay.
And they bought those units, and when the developer tried to put together all the rest of the unit owners to sell, the other 3 say, no, we're not selling. And there was nothing into the declaration that said that the board has a right to buy them out. So the deal fell through and the developer wasn't able to buy that condominium, tear it down.
Yeah, part of what you're talking about is the guy was going to have to terminate the condominium next door in order to build a new bigger one.
Yeah.
And to terminate a condominium, you need the consent of all the unit owners.
Yeah.
The board, being owner of 3 units, wouldn't consent, and that stops him. But the reason this is important is to realize this is one of dozens of types of restrictions that are set forth in declarations, but it's also something you need to think about when on a speculative basis you buy a condominium unit and you decide I'm going to lease it out. I live in a condominium that says for the first year after you take title to the unit, you may not lease it to anybody, period. We don't care. No leasing for the first year to discourage speculators. They can do that. They can turn down your tenant and, hopefully you go find another tenant. If times are tough, well, you sue the board and you fight over it, and you know. The point is, this is probably the most important restrictive type concept that's in a condominium declaration, and most people don't realize it's in there. Until they, and my point is, they don't realize it's in there if they buy it from the developer. Because the developer doesn't need any board approval. The developer sells to whoever he wants to. Or the developer controls the board for those first sales. They find out in a subsequent sale, because as a buyer, they went before the board and got approved themselves. And it's pretty hard to claim, gee, I didn't know about that, if you buy a resale. But buying from a developer, which a lot of offshore investors buy a brand new condominium as an investment and don't realize that there'll be restrictions on their ability to lease the unit. Yes, sir.
How does it work if you buy from the developer and there's no rules on like the size of the dog that you can have? And then
Size of the dog, did you say?
yeah, the size of the dog.
Uh-huh.
And then you're living there, and then they implement the rules saying, oh, you can only have dogs up to 30 pounds. But you bought from the developer, that rule wasn't in place, and you have a dog that's over that limit. What happens there?
That's discrimination.
They size it up.
Because I know, I mean, I'm just
I
using the
don't-
dog
I-
as an example, but I do that with.
I don't have the answer for you. I've seen them go both ways.
You could be legally non-compliant.
There you go.
What a court is going to look into, and this thing's going to end up in ultimately, all I can tell you is what a court will do with it. But you got to realize that what a court will do with it is probably 3 years and $20,000 in attorney's fees later, and the dog may be dead by now. What ultimately happens is screaming and yelling, and it's politics. You know, trying to get the board members to agree. Well, but there ought to be an exception for existing dogs. I mean, this is all. These are we're going to talk about in a minute. A condominium association is considered to be quasi-governmental, and it has to operate under some provisions of constitutions, which means due process of law, and that's how lawsuits end up happening. But there is no question, there is absolutely no question that the board has the authority to change the rules. Absolutely. The only question is a question of grandfathering, which is what you're talking about, where like they change zoning and you're grandfathered in under the old zoning. And there's a lot of litigation over that, and I can't tell you in every case exactly what's going to happen. Just don't know. Okay. Now, the text mentions, and it's worth bringing out, I think, that this declaration of condominium is so important, such an important document that every purchaser of a declaration should be aware of and read, that if you buy a new condominium, or under some circumstances, a resale condominium, under Florida law, you have a 15-day period to cancel your sales contract, to read the declaration and make sure you understand it. The purpose is so that on the 16th day you can't say, gee, I didn't know that was in there. Absolute right to cancel the contract and get your deposit back. Going further under Florida law, if you're buying in a new property, you're going to be the developer is going to be required to give you something called a prospectus, and that's even bigger. That's the declaration and all kinds of other stuff. All kinds of other forms, all kinds of projections of expenses. When you buy a resale, there's limited information like that the seller's supposed to get from the board of directors to give to you as the purchaser, to give you the right to study for a period, and sometimes it's hard for the seller to get it from the board of directors. But in a new condominium, it's all available, and the state has approved all that information by the condominium division, and In a new condominium, that bigger document is called a prospectus that includes the declaration, and you've got a 15-day right to cancel the contract after you receive it. And you may not receive it the day you sign the contract. When you buy pre-sale out of a trailer for a condominium, a trailer that's on a site where there's going to be a building built here, they haven't even done it yet. And at some point down the road, they're going to give you the prospectus and they're going to make you sign a receipt, and the 15-day clock is going to start. And you have the right to kill the deal if you read it and I don't like what's in here. Never mind, deal's off. That's how important this thing is. Okay. There's another important document. And that document is called the bylaws of the association. And we haven't quite yet talked about what the association is. But the association, and we're going to get this some more, is a nonprofit Florida corporation that everybody who buys a unit as an owner is a member of. And it's a corporation like any other corporation, and it operates with bylaws. And these bylaws are attached to the declaration, and they tell you the rules under which the association is going to operate. How many directors it's going to have, how often we're going to elect directors, how many officers we're going to have, how we're going to assess the units, how are we going to divide up expenses here, how we're going to have the right to pass rules, and what the subjects of those rules may be. They are an important document that does not legally how did we create the condominium, but is how we're going to operate the condominium going forward. How are we going to run this thing? How are we going to manage it? And of course, just like shareholders in a corporation, if you're a unit owner, you're a member of the corporation. In nonprofits, we call them members. Nonprofit corporations are called members. You're a member of the association. It's the same thing as a stockholder in a corporation, except you don't have a share of stock. But just like in all corporations, the members or the shareholders elect the board of directors. So if you're unhappy, next year you vote for different directors. And like in all corporations, the board of directors elects the officers. And they're going to run the corporation. And the bylaws are the rules, like the Constitution for a government. The bylaws are the corporate rules under which the association is going to run. And the bylaws are going to give the association board the right to pass rules and regulations and to publish them and to change them from time to time and to enforce them. And to enforce them with fines, to enforce them with liens on your property. The association is pretty powerful. Okay, that's kind of the setup. Each unit owner, when he buys from the developer, or when he buys from anybody else, from another unit owner, gets a deed. Just like we get a deed of real estate. Well, I mean, of a regular parcel of real estate. This is every bit as much of a parcel of real estate, but like we get a deed with land description in it. In a condominium, you get a deed that describes your unit. And just listen to me, don't write this down, but here's what a condominium deed sounds like. You get a deed to Unit 202 of Happy Acres Condominium. A declaration according to the condominium thereof, recorded in such and such a book and page, together with an undivided interest in the common elements as set forth in the declaration. That's what the legal description of a condominium unit is. It's the unit, according to the declaration that was recorded, together with the undivided interest in all the common elements. And that's what you own, and that's what a condominium unit is not only the apartment, but also the undivided interest. Okay, these common elements we talked about. There are two kinds of common elements. There's basically general common elements, which is most people call common elements. And then there's limited common elements. Now, generally the condominium elements, the general condominium elements that are not limited common elements are all of this common stuff. The swimming pool, the parking lot, all of the land, the hallways, the elevators, the stairs, all the stuff that we're all going to use together that is not included within a unit. Basically, it's everything that is not a unit. It's everything that is not an apartment. That's going to be maintained by the association, and it's going to be regulated by the association, all these common areas. There are some special common elements that are called limited common elements. A limited common element is a common element just like any other common element in the sense that it's owned by everybody. But its use is limited to a certain owner. A balcony is a limited common element. You think it's your balcony. It's right outside your unit. Only you have access to it. It's not a part of your unit. It's a common element. It's owned by everybody. It's maintained by the association and by the assessments levied by the association. But its use is limited to one unit owner. Parking spaces. In the condominium where they assign parking spaces, they don't all. In some condominiums, it's the most important thing in the world, and people are suing each other daily over parking spaces. Undercover parking spaces versus outdoor parking spaces. In some condominiums, the parking spaces are limited common elements. That means they're maintained by the association, but their use is limited to one person.
No, I was just gonna bring up back to the penthouse thing. Like if there was an elevator specifically for the penthouse owner, like say he had the key that got him over to the top levels, would that be considered under limited?
It all depends on what the declaration says. The declaration defines the common elements. I think it would be determined based on really the ownership. The ownership is not a big deal. It's who's going to maintain it and take care of it. And I think that's where the factor is going to come in. Who's going to have to pay the maintenance contract on that thing and pay for repairs on it? A lot of people are going to say, shouldn't be me, he's the only one who gets to use it.
Yeah.
I can see that argument, but there's also the argument that, yeah, the association, you're maintaining all the other elevators in the building, it's no big deal to do this one too, you know. I can see arguments both ways.
And he's already paying a
Higher association.
higher association fee because he probably has the whole floor if he has an individual elevator going up there.
Let me say this, if it's not to be maintained by the association, and if it's not to be owned in common by everybody, then in what situation you're talking about, it's going to be a part of the unit. The declaration is going to show that elevator as a part of the unit.
Okay.
Okay.
What I've seen is if the elevator does not stop in any other floor, only goes to your floor, the association will maintain the elevator, but you own
Yeah.
the elevator. And if you have to repair it or change the motor of the elevator, it's on you because it's part of the unit.
Mhm.
If it doesn't stop in any other unit.
But what if it does, but you have a key that kind of turns it?
If it's stopping the rest of the unit, it's a common element.
Okay.
It's limited, at least in what I have seen, is if it doesn't stop in any other unit, just in your
Then
unit.
it's part of the unit.
They maintain it, but if there's something broken or you wanna fix interior, it's up to you.
Respectfully, I don't think that's an issue any of us are gonna run into. And I don't know the answer to it.
Just check.
Okay, now, know if you would, and we're gonna talk about assessments in a minute, but each of these common elements, the important thing is that the board is gonna have assessments collected from all of the owners to pay for the maintenance of all of these common elements. And that means that all of the owners are paying for the maintenance of your balcony. And you're paying for the maintenance of everybody else's balcony. And of course, there are 100 reasons for doing that. We want everybody's balconies to look the same. We want them all to be painted at the same time. There's a safety reason. So the association wants the ability to repair the balcony. Because if the one on the 5th floor collapses, it's probably going to be bad for everybody down below too. So there's certain things that you want the association maintaining for safety reasons, even if it's only used by one guy. All right. There is an association. We've talked about them. I think we probably hit on them enough already that the separate discussion of them. In fact, we've already covered separately everything that the book talked about. There's a board, it's going to run the association. Members of the board have a fiduciary responsibility to the unit owners. That means don't steal the money. Do what's best for everybody. And do what's right in terms of constitutional provisions. Be fair, operate openly. Associations are heavily regulated by Florida statute, heavily regulated by the division, and they have all kinds of rules and regulations, how to keep their money, how to ad nauseum. Okay. The association collects assessments. That's to pay for all the costs of running this place. The lights for the common areas, the lawn man, the repaving, fixing the roof. All these things have got to be done and got to be paid for. And got to be paid for by the unit owners. There will be a regular monthly assessment that is based on the percentage, which usually is based on the square footage. In other words, if it costs us $100,000 a year to run that condominium, probably everybody's going to pay $8,500 per year, divided by 12, $700 a month. That's your regular assessment. That's the biggie is insurance on the whole building. The association insures the fire and maybe hurricane insurance, maybe not, on the entire structure of that building. Not necessarily what's inside the unit, but the structure of that building. And maintenance, the yard man, electricity, all the expenses of running the association, including the biggest being insurance, are regular assessments. In addition, every now and then, there's going to be a special assessment for something. Okay, it's time to do the roof. Everybody share the roof, another 10 grand. Some associations, and they're supposed to, but they don't all do it, collect for that monthly into kind of a sinking fund and save for the rainy day for when the roof is coming. Others don't. They're required to, but they just don't. The point is, when the board decides that there is a big expense coming down that's got to be paid for, it can make a special assessment against all the unit owners. If you don't pay your assessment, the condominium association gets a lien against your unit. If you still don't pay, the association can foreclose the lien against your unit, and the association can take your unit. Just like a bank would foreclose a mortgage, the association can foreclose its lien, can take your unit. I want to make one comment for a second. When we talked about Florida homestead last time, we talked about that either if you own units by entireties or if it's your homestead, some of these special exceptions about ways that they can't take the property away from you, they can. In a condominium, you have agreed by buying subject to the declaration that my unit is subject to a lien, and that if I don't pay, association, you can sell my unit, and I'm out, and association owns the unit and can sell it. Yes, sir.
Is there interest on past due assessment?
Is there what, I'm sorry?
Interest.
Is there
on
interest?
Past due assessment.
There can be, if it's not paid when it's due.
That has to be set up in the bylaws in the beginning?
Yeah, they'll have a provision in the bylaws. They're late charges, and then once they file a lien, interest will run on the lien.
Oh.
Usually what happens is this. If you don't pay by the 15th, there's a late charge. If you don't pay a couple of months later, the association will file a lien. Interest and attorney's fees run on that lien. And then if you don't pay for a while, the association can file suit and foreclose the lien, just like a lender would foreclose a mortgage, and has a lawsuit in the courthouse and says, Your Honor, this guy hasn't paid, please take his unit away, I will sell his unit. Yes, and that's mechanically how it works. That's simplistically, but that's it. You had a follow-up, go ahead.
Yeah, can you put it on the market and stop that process from happening?
I'm sorry, I didn't hear you.
Can you put your condo on the market and stop the process of the lien from happening?
Well, you can sell it, sure. Doesn't mean they don't have to be paid, though. The time of the closing, it's going to be paid.
Okay.
At the time the buyer sits down to give the money to the seller, before the seller gets his money, whatever's due to the association is going to go to the association to catch them up. Just like paying any other lien or mortgage. Yeah. I mean, yeah, you can stop paying and sell and hope like hell you get it sold before the association finishes its foreclosure.
Yeah.
Or else they're selling it. Yes, ma'am.
Is it the norm to do things to the specific unit outside of a lien? Meaning, I've heard of instances where people have had their water turned off.
It's because the association didn't have the funds
To place the
to
lien.
pay. Are you suggesting the association is going to turn the water
the
off on
individual
this
unit.
one unit owner who's not paying?
Yes.
They don't do that.
Okay.
They don't do that. I don't think they're allowed to. I've never seen that done. They can say, and they have said, you can't use the pool, you can't use the fitness room, and I think they've been upheld in saying that. There is so much litigation over condominiums. I'm not gonna bet you. Of all the litigation that's not mortgage foreclosures in the courthouse, which is huge, I'll bet you the next highest thing is condominium litigation. People fight over everything. It's just, it's horrible. And lots of them is stuff just like that. And a lot of times, what you gotta realize though, when these associations are foreclosing their lien against the unit, well, usually if the guy isn't paying the association, he's not paying his mortgage either. And his mortgage is getting foreclosed. And it's the lender that's gonna get the unit back and sell it, not the condo association. And then there's certain statutes about how much of the money does the lender have to give to the association to help catch them up. But the downside in all this you gotta realize is, when a few unit owners aren't paying, everybody else somehow has to make up the slack. Because that electric bill has to get paid, and the lawn man has to get paid. And we're all getting hurt here when this one unit owner is not paying. So it causes a hardship, but at least there is some remedy, but it may take 2, 3, 4 years for the association to get the unit back and be able to sell it to somebody who will pay. But in the meantime, all these bills keep coming. Yes?
Do they lease it, the condo association lease out?
They have the right to. They have the right to. They can sell it or lease it, either one.
To help
Once they become the owner, they can do anything with it, just like you or I could.
They can't sell it, because the bank's note, if there's a note on it, will supersede the.
They can sell it subject to the mortgage, sure, the mortgage is still on there.
Right.
Not gonna take away the mortgage. Yeah, you know, forgetting issues about the bank, if the association obtains ownership, I've seen where they kept a unit and turn it into a library.
Wow.
But usually they want to get it back out there with somebody paying to help with the expenses. Whether by lease monthly or by purchase price and a guy paying regular assessments. Okay. I think we better break. We're going to do co-ops when we get back, and we're going to wrap up this chapter, and then we're going to try to move. We're going to stay out for a half hour until, is that 10 after yet?
Sure.
Yeah, okay, we're going to crank up promptly at 20 minutes of 2, and we'll start with cooperatives. And try to move faster.
If the contractor puts a lien on the contract for like non-payment,
Mechanics lien.
that affects
I don't think I'm eating anything.
all the inputs
So I ate this morning.
as far as.
I'll go
Theoretically.
grab my Tandor shots.
Theoretically,
What was,
it leans this undivided interest in the common elements. It really doesn't hurt the number unit order when it's time to be finished. If your lien is strictly on unit 202, and I'm doing a deal on 203, I'm not talking a lot about the fact that you got a lien on maybe his 8.5% interest in the common elements.
Okay.
Theoretically, it can be a problem. Usually, it comes about when somebody's done work for the association, and the association doesn't pay them. And then they lien the whole damn place, and that creates a real problem with closings. That can be
So,
huge.
because I've got an investment property in a condo, a newer building, that the contractor did not do something correctly, so the association is suing the contractor,
Uh-huh.
and the contractor is now countersuing. So they leaned,
And he tried to lien all the units, is that what you're saying? He filed a lien
I think
against all
he
the
did.
units? Okay, and it,
because I had to, I was gonna sell that unit. I still need to talk to the association about it or find out, but I had heard that, that lenders would only finance it for like 50%.
It
because
can
of
present a
that.
problem because they have concern about it. From a title examiner standpoint, a lien against the association is a concern. A lien against a different single unit is not a concern.
Okay.
In terms of prohibiting closings on other units, you know. But yeah, a big association lien can stop all closings in the condominium.
Yeah.
Because every title examiner is gonna take a look at it and say, hey, they've got a lien on all the common areas. Not that they can really, not that they're really gonna be able to take away the parking lot,
Right.
but basically it's just an encumbrance.
Right.
Yeah.
Okay.
Okay.
Yeah, Rob, you exceeded your question limit, man.